Ms. Kuzwai, before you address us, I just want to highlight that the court started late this morning because we did not have your written submissions, and we thought it might be our fault. And we discovered that you were actually involved in this matter only at 9:45 today. Now, it has been established that your heads were never filed with the General Office of this court. Why should we allow you to address us?
Gone as far as being enacted or brought into action. So in this regard, I would also like to bring it to the attention of this court that the province of KwaZulu-Natal has gone as far as publishing their intention to award a tender to a successful bidder regarding the elections of the traditional councils in respect of the TKLA as required by Section 21. So looking at those issues, I think this court needs to take into consideration the time that had lapsed after the applicants filed this application. Furthermore, I would like to refer on this issue, I would like to refer this court to the case of the Doctors for Life, which has been relied on by the applicants. I would like to refer this court to paragraphs 65, that is on page 34 of the case, and then paragraph 216 on page 113, where In paragraph 65, this court concluded that it is competent for this court to grant relief in respect of the provisions of Parliament after the bill has been enacted into law, but before it has been brought into force. So that's where I think this matter differs from the matter or the case that the applicants are relying on. That in that case, the act had not been brought into force. Yes, it had been enacted. Again, on paragraph 2 and 6, this court stated that it will only consider an application to declare legislation invalid in circumstances where the applicant has sought and been denied an opportunity to be heard on the bills, and where the applicant has launched his or her application for relief sought in this court as soon as practicable after the bills have been promulgated. On this submission alone, I submit with respect that this application ought of falls to be dismissed. Regarding the issue of the sixth respondent having participated or conducted itself unreasonably when conducting the public hearings, I respectfully submit that the applicants here seem to have set up some certain standard or some level of perfection that had to be used by the respondents when conducting the public hearings. The sixth respondent had conducted hearings at like 8 areas in the province. I agree that the place of Kokstad was repeated, which may have been an error on the part of the sixth respondent, but then it was still benefiting the public. It may be accepted that there may have been some imperfections in the manner in which the public hearings were held. However, all that the sixth respondent was doing was reasonably possible at the time. There were also time limits that they had to comply with when conducting those hearings. If I may also set out what exactly was done by the sixth respondent in facilitating public involvement. Like I said, there were 8 hearings that were held, but before those hearings were conducted, there was a pre-hearing workshop that was conducted, and then there were summaries of the bill that were provided in as much as they couldn't be in every language involved in the province. They were drafted in simple English, and they were, during the public hearings, there were interpreters who were there to assist should there be someone who says, no, I didn't understand what was said. They were given that opportunity. My learned friend, in respect of the third and fourth applicants, raised an issue I'm sorry about that.
The protected 10 minutes is up.
Pardon?
You can expect questions from now on from the bench.
I can explain questions. Yes. Okay, okay.
Ms. Kuzwayo, a small but very important issue. The coup in your surname, is it the old or new orthography? That is, do you have an H or don't you? I want to write it correctly in my book.
It doesn't have an H because that was a typo from Home Affairs.
Oh, all right, all right, all right. All right. I'm going to ask you a question that may not necessarily relate to KwaZulu-Natal. But overall, I think it does bear relevance to what the fate of the whole matter should be. Would you say, and I'm asking this question because in the submissions that you have made, you say that we should not expect perfection. And you seem to suggest that what may not have been done properly were just mere minor imperfections. Did I understand you correctly?
Yes.
All right. Would you say giving a 2-day, 3-day notice is a minor imperfection of public hearings?
I would say it wasn't that huge perfection because imperfection, because yes, there's one area where the province did not provide for transport.
I said, don't focus on KwaZulu-Natal. I'm just, it's maybe even relate to other provinces.
Okay.
Yeah. 2 days notice, 2-day, 3-day notice for public hearings.
It's not actually good, but here we were not looking, in my mind, it seems like the applicants have set up some standard that.
But just address me on this one aspect, please. Just this one aspect.
As I'm saying, they may not have been perfect, but they did give out those notices. And
Let's not talk about the past. I'm just asking as a general question or issue. Giving 2 days, giving 3 days for the required notice.
forced by the circumstances, I would say you do whatever you can in the circumstances. So at least rather than not give anything, you try your best to say, here is the notice, this is what is happening. Be as it may,
Okay.
it was done.
Of course, that raises other issues because then there are issues of urgency and so on. And what I understand is that there were no questions of urgency with this legislation. Anyway, I will leave that.
Yes.
We are told that with regard to Gauteng and Mpumalanga, the attendees were told not to worry because the legislation did not concern them and that all it was about to bring within the fold the Khoisan people. That was obviously not correct. Do you accept that?
Yes.
I know Gauteng and Mpumalanga have nothing to do with you. So that was not correct. Was that a minor imperfection? Effectively, if that's correct, that's a lie. The people were told a lie. Is that minor? On something that goes to, is the fundament of what all of this was about.
In my
Because they
view,
can only contribute to the public debate if they know what the legislation is about. So they are told a lie. This doesn't concern you. It only concerns the Khoisan people. Was that a minor imperfection?
it wasn't minor unless the parliament had decided that those who are conducting public hearings do not have to listen on each and every issues that are raised. They may have been given some instructions how to work on.
To lie? Are you suggesting they may have been given instructions to lie to the people? What are you saying exactly? I don't understand.
I am accepting that it wasn't right.
It
if
was
the-
not minor. You
wa-
accept it
yes,
was not a minor
It wasn't a
imperfection.
minor issue.
It was a
And
very
unless there was a
serious,
decision.
serious misrepresentation.
Yes,
And the people attending there could not have been expected to be able to meaningfully contribute to the debate. Do you accept that?
yes.
Yeah. Now, the next thing I'm going to move to is, if that be the case, what should the fate of the legislation be?
This takes us back to the issue that was raised or dealt with by this honorable court, that with the act not only having been signed by the president, but having been brought into force where, like my province has even
Let's just
acted
say,
on the same act.
let's just use this phrase. I do not even know what it means exactly, but I do have an understanding, and I hope you all also have a similar understanding of it. All things being equal, but for just this one issue, this serious misrepresentation, or this misrepresentation that you accept was quite serious, and which goes to the fundament of what this was all about. Let's forget about when was it signed and when was there delay and all of those other things. What should the fate be? Should that not lead to invalidation? Everything being in place.
Justice, if I may address this point to you, I think
Let
this-
me,
I think this
I'm very sorry to speak over you. Let me tell you why I'm raising this. I'm raising it because I'm trying to establish to what extent a debate that says, but no, KwaZulu-Natal is fine. No, the Western Cape is fine. If there's a whole lot wrong with what went on elsewhere, I'm not even accepting that everything was fine with KwaZulu-Natal, nor am I accepting that everything was fine with the Western Cape. But I'm just saying, where there's something glaring with regard to other provinces, does that help? The fact that KwaZulu-Natal may be fine, the Western Cape may be fine, does that help them at all? That's where I'm going with my question about this one issue that you accept was quite serious and not a mere small imperfection.
I am going to respond, although this is some kind of hearsay, that in those other provinces, the applicants were given opportunities and they did nothing to raise their concerns or their input. I am being asked by something which I wasn't there, and I am telling you what I was told.
I'm asking you purely as a matter of legal principle. If something went wrong in Gauteng and Mpumalanga, and you accept that it was quite
wrong.
serious, it's quite serious, it's a serious shortcoming in the public hearing process, what should happen to the legislation as a
I would
whole?
accept
You cannot,
that.
I'm asking this because I think you cannot say, but this legislation is valid insofar as KwaZulu-Natal and the Western Cape are concerned. That's where I am.
I do accept.
Would you accept that as a legal
that,
proposition?
That if one party may have done right, and if the other party was so wrong, then whatever the other party has done correctly interferes or impacts on the other one. I'm not sure if I'm clear.
I'll leave it at that, Ms. Kuzwayo. Thank you very
And
much.
the one last submission I wanted to raise is that reading the notes of motion and the reasons that they want the act to be declared invalid, and then considering the whole issues that are raised in their founding affidavit, to me, I submit, it appears like they are against the whole act, the whole TKL Act, not what was done there. They are criticizing almost most of the things regarding this TKL. And in my view, they just used the wrongfulness, whatever transpired out there, but to achieve another aim. Those are my submissions.
Ms. Kuzmayo, I need your assistance, please. I have a note here to refer to paragraph 18.4 of your answering affidavit. Could you tell me where I can find that in the record, please? I don't have a page reference for it. The answering affidavit filed on behalf of the sixth respondent. Thank you.
18.4, yes. I'm there.
Yes, paragraph 18.4 of the answering affidavit.
Yes.
Yes. Where can I find it in the record, please? Can you assist?
Page 2147.
Page 2147. Yes, I'm sorry I can't find that, but I have a note that there were only 4 public hearings held in KwaZulu-Natal. And in your submissions earlier, you said there were 8 hearings that were held. What is the correct
Justice
situation?
Thorn, there were 4 hearings that were conducted by the Portfolio Committee, which were held at Vryheid, Hluhluwe, Pietermaritzburg, and Kokstad. And then the 6th respondent tried to schedule other areas which had not been visited by the Portfolio Committee. They visited another 4. And that is where I say the Kokstad was repeated in this event. And I am saying it may have been some shortfall or an error on the part when they were arranging those areas that nobody picked up that they were repeating Kokstad, which may make it 7 then if we say they visited twice at Kokstad.
And is it correct that formal pre-hearing sessions were only held in Vryheid?
I beg your pardon?
Is it correct that formal pre-hearing sessions were only held in Vryheid?
My instructions are that there were pre-hearings that were conducted before the invitations were advertised on the newspapers and all that.
Where does that appear in the papers? Can you refer us to that, please, Ms. Kuzmayo?
Like I said, I'm not certain if I was given something to support that, but all I'm saying, there is a paragraph where I indicated that in my affidavit. That will be at paragraph 61, page 2158.
Is this volume 23?
Yes.
And see, it says that confirms what I'm suggesting, Ms. Kuzwaya, that one pre-hearing workshop was conducted in the entire province. And that was only in Vryheid, because paragraph 61 also refers to a pre-hearing workshop.
That may be the correct fact if it's how it states. And at paragraph 33 of the same affidavit, page 2151, that's where the 6th respondent stated that they provided summaries of the bill.
Now, the case made out by the applicant while we're on the summaries is that the summaries were misleading and that there were copies of the bill were not made available. The summaries, the misleading summaries were made available, but copies of the bill were not made available at the hearings.
The 6th respondent conceded that the copies of the bill were not provided due to their financial constraints.
And it would also appear that most of the people attending the public hearings were told this is a hearing about land.
I cannot respond to that because client never considered that to me.
If all that is correct, how does that impact upon the process that was carried out in the province?
Even if they were those allegations by the applicants are correct, I still maintain that this court has to consider that the applicants had to approach this court as soon as it was practicably possible after the bill had been enacted. So with them having stayed so long before filing their application, that issue will definitely
Let's
fall
assume
away.
for a minute that this court is prepared to entertain the application. What would your answer to my question be?
If the court entertains the application.
Let's assume that the court entertains the application. Let's assume, based on the assumption that the applicants have standing, what would your answer to my question be?
My answer would be that, as I said, to me, it seems like the applicants are seeking the respondents to have acted perfectly to the fact that if there were points allocated or there was a schedule listed to say do this, they would have expected the provinces or the National Assembly to get like 100%. And that's not how one gets a good or an excellent or A in the past. We don't have to get a total. There may have been some things that were wrong or right, not rightly done or correctly done, but still that will depend on how far or how much the wrongs were.
So if you were marking these papers, would you give the provincial legislature an A? What would you give the legislature? Or would you give them 10% because you also mentioned 10%?
Look, considering if the provinces had made the invitations, had made those pre-hearings, which are alleged to not have been reasonable, they will be getting some marks or some points on each of the things that are raised. So eventually, we may find that they may have scored some 70 or some 80 points or whatever they did. So that's why I'm saying it is unfair or unreasonable for the applicants to have expected, like, if we look at the issue of
No,
the
Ms.
KwaZulu-Natal.
Kuswayo, that was almost a tongue-in-cheek question.
Okay.
It's a difficult question to address. Thank you very much.
Thank
Deputy
you.
Chief Justice.
Thank you very much, Ms. Kuzwai. No further questions for you.
Thank you. As a please.
Deputy Chief Justice, Justices, the law that we're dealing with is contentious, it is contested, but this is not a case about the substance of the law. It is a procedural challenge. The applicant seeks specific relief against the Western Cape Provincial Parliament. In that regard, the defense is not in terms of the provincial legislature being a cog in the wheel of the NCOP process, but specifically whether it complied with its obligations in terms of Section 118. The Western Cape Provincial Parliament opposes this specific relief and is of the view that the relief must fail, one, for lack of standing, and two, because it complied with its obligations. Just the background to this, there were 73 public hearings in general. First, the NA had 2 days of hearings, followed by 28 hearings in 9. The provincial legislatures had 43 hearings, 6 of them by the Western Cape Provincial Parliament. This process ended for, the public hearings ended for the Provincial Parliament on the 6th of May 2018. This application was launched 3 years and 7 months thereafter. And despite sending monitors to monitor 3 of the events, absolutely nothing was said. And in many cases, it's something akin to first dealing with your internal remedies. There should at least be some kind of notice that you've been defective so that it could be corrected. What the applicants tell us in the replying affidavit is that the first and second applicants attended 13 hearings. They made 8 submissions. In the confirmatory affidavits to the founding affidavits, there were 20 monitors that attended 60 hearings across the provinces. They sat, they observed, they said nothing. And this speaks to the heart of standing. The clear grievance is clearly with the substance of the bill. And the applicants state that should this challenge fail, they will launch a substantive challenge. In the replying affidavit, the applicants ascribe part of the delay is that they wanted to consult on the impact of the bill, not on the public participation. The Western Cape Provincial Parliament, despite voting against the bill, opposes the application for 5 reasons. The first being one of principle is that the constitutional system was never intended for procedural challenge to stymie legislation passed by a democratic legislature. We're not in the dark days of apartheid where there's no substantive relief. We have a justiciable Bill of Rights. This court has never flinched to uphold these rights. Second, repeated procedural challenges which seek to aim substantive redress, they incrementally set an unobtainable benchmark by legislatures which are small, which are unresourced. You deal with a committee of 6 members dealing with an entire province with a limited budget. The challenges relate to, they create enormous uncertainty in the legislative sector. What the provincial parliament regarded as exemplary, we told is defective. Not at the time that it was happening, not at the time that they could do something about it, but now. The fourth is that the provincial parliament opposes it because of the extreme delay and the principles involved. Fifth, in Doctors for Life, this court said that legislatures have significant latitude, but what happens is that the minutiae of the details they trip up the process. I think Justice Moran asked a question about, it was Justice Madlanga that said that, did the legislature mislead people? We have to also remember that legislatures are elected members. And to ask a question like that, the question in essence should be, did they act reasonably? So looking at the long title of the bill, looking at the presentations by the department, when a legislature makes a mistake like that and they misread the bill, does that amount to unreasonableness? The answer is no, because part of the public participation process is to elicit this, is to point out the mistakes where unintended consequences happen. I want to address the applicant's lack of standing. As we mentioned before, there was prior participation, but no prior warning, no prior complaint. And the application was launched 3 years and 7 months after the hearings took place, 2 years and 10 months after Parliament passed the bill, 2 years and 1 month after it became an act. I want to deal with the issue that you dealt with, Justice Taron, on standing. And this court has differentiated in Cagliani between a procedural challenge and a challenge in the Bill of Rights. In that regard, in Cagliani following Doctors for Life, the court said, save in very exceptional circumstances, late challenges should not be permitted. There's a strong need for procedural finality, which should not be confused with the ever-present right to challenge the constitutional consistency of a resultant law. And that's where your answer lies. The restricted approach to standing has been followed in Doctors for Life, in Cagliani, in Mautse, in the Poverty Alleviation Network. And this is what the court has said, where the issue relates purely to procedure and where there's delay, the applicant should be non-suited. There was an issue of whether Doctors for Life was obiter. The issue on standing arose because somebody wanted to make a participation on, I think, the traditional medicines bill and was refused. But that obiter statement was subsequently adopted by 4 decisions of this court. So in Doctors for Life, this court said the applicant must have sought and been denied an opportunity, and they must also launch an application as soon as practicable. Doctors for Life said standing discourages interest in the duty. The 11th respondent witnessed participation happened, but nothing was mentioned. And if at the root of the problem lies inequality, lies challenges to the Bill of Rights, then that kind of challenge must be brought. It shouldn't be brought through the back door of a procedural challenge, because literally what's been asked is that the court would have to legislate, dealing with whether this sounds right or doesn't sound right. This is a procedural challenge. In Cagliani, this court said that restricted standing reflects this court's concern to protect the institutional integrity of Parliament. And save in very exceptional circumstances, late challenges should not be permitted. In Mautse, it was said, even parties who have claimed to be denied the opportunity to participate cannot sit back and years later challenge public participation. In the Poverty Alleviation Network, Justice Nkobenda said, without delay, it has to be instituted. This is to ensure stability, legal certainty, and that impugned legislation has practical and budgetary consequences, and it implicates the daily lives of millions. And just looking at that, if one looks at the Appropriation Act 10 of 2021, 103 million has been allocated to roll out the act in question. This has been spent. In
The first
poverty
10
alleviation.
minutes is up, Mr. Fasan.
Thank you, Deputy Chief.
Mr. Wilson, I didn't get your submission, the essence of it about Gauteng and Mpumalanga. What exactly are you saying? I would imagine that the people who are given the mandate to conduct on behalf of the legislature concerned, the mandate to conduct the public hearing, that is, engage with the public. I would imagine that that would be people who know what the legislation is about. They cannot just grab a legislator from the street and one who knows nothing at all about the legislation in question and say, please go there today and be the one who conducts those public hearings. So if you accept that it would be people who know, or at the very least who should know what the legislation is about, is it reasonable? I'm raising with you at the level of the language that you chose, which indeed accords with what this court's jurisprudence has said. Would it be reasonable for those people who know what the legislation is about to tell them an untruth?
If it was an untruth that was deliberate, it's unacceptable.
Sorry?
If it's an untruth which is deliberate, it's unacceptable. But the one thing to consider, Justice Madlanga, we don't have a criteria who can become a member. A lawyer can become a member of the legislature. A factory worker can become an unemployed person. Somebody with zero education can become a member. What happens if that context needs to be looked at in what would be interpreted to be reasonable? So if you read the long title, and this is what it says, it deals with Khoisan, etc. If you read that, and this is the presentation by the department, then it wouldn't result in unreasonableness per se, because that was the understanding. And part of the public participation process.
Whose understanding?
It is the members' understanding that would have that, because these are not justices, and even judges get matters wrong, they get taken on appeal. We're talking about lay people that are members, and this is the understanding of the bill. So I think a differentiation needs to be made where there's a deliberate misleading of people saying you're excluded when we know you're not. We basically want you to be quiet. We don't want to hear you.
Is it not unreasonable to send people who do not understand the legislation? I will accept your point. I will accept your point that not all legislators will know what the legislation is about. But I think we should go a step back. Is it reasonable to choose those legislators who do not know what the legislation is about? Because what's the point? What's the point of engaging with the public on legislation that you either know nothing about or you know very little about? What's the point of it? I would think that's unreasonable.
Justice Madlanga, the answer is found in the UDM case, that where the Constitution specifies it, that is how it is. the Constitution doesn't make a criteria. It doesn't have a criteria.
There is
who
a
can-
criteria on reasonableness on this point,
on
on the
reasonableness-
point I'm engaging you in, and I'm saying, let's take it one step back. Is it reasonable to send people to engage with the public? For it to be meaningful engagement, it must be with people who know what the legislation is about. So is it reasonable to send people who either do not know what the legislation is about or know very little what the legislation is about? Is that reasonable?
Justice Matlanga, that is the political system. A political party will nominate a member. That is how the system is. The
So
unreasonable.
you can just throw names in a hat, and then pull out.
Well, unless Justice Madlanga is suggesting that
I
we
will-
need a criteria that
I
you can
will-
only have this level of
No,
education.
the
Because in our
criterion is
country-
reasonableness. The criterion is reasonableness, and I'm engaging you on reasonableness.
But Justice Madlanga, in the context of our country, where there's been apartheid, there's been deprivation, there's been exclusion, to have a criteria like that for a member of parliament is the difficulty. So sometimes I'm saying this happens. And I'm saying that what should be distinguished is where somebody deliberately misleads people to say, we don't want to hear you, and where the member, him or herself, misunderstands what the law is. And the criteria of reasonableness would be determined by how that was understood. If there was a deliberate act, then it's completely unacceptable. If it was, and this has happened in many cases where legislation is passed, the full implication of the legislation is not ascertainable. What happens, interested members, groups come and say, look, this is the problem with the legislation. We didn't know that. And this is the value of public participation. And we have interested groups, we don't just have marginalized groups, and they contribute and they make that legislative process valuable.
Mr. Wesson, can I ask you two questions? The first is, do you accept that in considering the question of reasonableness of public participation, which is the central question in this case on the merits, that we must look at the inadequacies and the shortcomings cumulatively first, and then second, also look at what has happened right across the country? We can't isolate it into compartments and tick boxes. Well, Western Cape did okay, but Northwest didn't, and so on. Do you accept that this is an exercise that requires a cumulative look?
Yes, Justice Majid, I agree with you.
And therefore, even if Western Cape did what it could and did to the satisfaction of the criterion of reasonableness, if there are shortcomings of the nature the applicants allege, and it's proved on the papers that these inadequacies permeate throughout the process in the National Assembly, the NCOP, and even in the provincial legislatures, that then we must make a decision based on that, not on the Western Cape's position.
Then, Justice Majid, that would fall under Section 72(1) with respect, not under Section 118.
Yes, but this is a national bill. I mean, we don't even have to
Yes,
debate
but
that.
it's that plus also Section 118. This is the specific reason that the Western Cape Provincial Parliament has opposed this, because they thought that they performed in an exemplary manner. And to be found to be wanting in public participation is something that the legislature finds very difficult, where it has contributed as a legislature from a provincial perspective.
Well, that's almost like a litigant coming to court and saying, you know, you've made adverse credibility findings against me, so I'm not really going to attack the order. I want to attack your reasoning where you made these adverse credibility findings. Isn't it something analogous to that?
But Justice Majid, there's a distinction between Section 72 and Section 118. If you say, if Section 72, if they failed, the legislation will be set aside. But what the Provincial Parliament doesn't want is a specific declarator that it failed in its constitutional obligation.
Yes, then the other second question is it your case that simply because these applicants did not participate in the hearings in the Western Cape, that therefore they have no standing to complain?
It wasn't as counsel for the applicants put it across. It is that they have standing in terms of Section 72, but they're also seeking specific relief against the Western Cape Provincial Parliament. So where you didn't participate, that becomes a problem. More than that, Justice Majid, is the fact that if you monitor 3 hearings and you say nothing, and you don't say anything during the whole process, you shouldn't be able to be allowed to come, in terms of the jurisprudence of this court, to come back 3 years later and say, but you have failed. Because the ship has literally sailed. If there was a letter to the speaker to say, look, this is the problem, you need to fix this didn't happen, that is understandable.
I don't understand the practicalities of that. How do you interrupt a process midway through, which is a national process? You have deployed people all over the country to monitor as far as you can within your limited resources. How do you stop the ship midway without having a global look comprehensively to see whether this process has been adequate? Surely that's a process that must be, it's an exercise that must be done once the process has been completed, so that you could look
This
at it
court has
holistically.
found that not to be the case. It has 4 or 5 judgments which consistently apply the delay principle. And the simple thing is that you simply write to the legislature to say there was insufficient public participation. This happened, there wasn't a bill, this wasn't true public participation. The legislature then has an opportunity to respond.
I must say, I find that difficult to understand, again, how you do this in a process of a national bill where there's national consultation, and then you are supposed to say, well, here there's a fault here and there's a fault here. Where is it all going to end up? Aren't you expecting too much of the general public?
Justice Majid, you have people that have LLMs sent to monitor the situation. In Doctors for Life, people complained that it wasn't sufficient. They were ignored, and they were ignored to their peril because the legislation was set aside. It was brought to their attention. And I think this is precisely the point where this court has adopted a restrictive approach to standing, is that where you simply cannot let the process go by, wait years afterwards, and then challenge it.
Mr. Hassan, thank you. I'm intrigued by your notion that the failure of the monitors to bring the shortcomings to the attention of the provincial legislatures somehow dilutes the duty of the National Assembly, which is peremptory in Section 59, that the National Assembly must facilitate public participation. So quintessentially, it's a duty that rests on the National Assembly. And while there might be some criticism that one could direct at the monitors for not doing it, and my brother Justice Majid has raised the practical difficulties, surely that cannot mean that the answer to the question whether the National Assembly has discharged its constitutional obligation should be answered any differently.
I agree, Justice
Okay.
Colvin. But there's obviously a differentiation between Section 59, Section 72, Section 118. And where you're saying this legislature has failed, have you brought it to their attention? And I think...
So your mic is off, I think.
I think that is the essence of the question. If you're observing this, why are you sending these monitors? Is that not the question that Doctors for Life asks? Are you truly interested in public participation? If you're watching these things happen, if you're sending people, why do you not contact the speaker? Why do you not tell the committee that this is insufficient? Why do you not say that this is defective? And that is the essence of standing.
Mr. Vassana, I just think one should be careful that you don't seek to imply that the monitors were waiting for the process to fail. But my other question is this, and it really arises out of the question of my brother, Justice Madlanga. If a member of the legislature, not deliberately, but bona fide, makes a misrepresentation with regard to what the content of the bill is, and that misrepresentation results in somebody not participating, then surely the honesty of that misrepresentation cannot mean that, well, hard luck, you didn't participate. The substance of the issue was the public participation. And if public participation did not take place because of a misrepresentation, even an honest one, then that's the answer to the question, surely.
Justice Colvin, with respect, the criteria is reasonableness. So if under circumstances it's unreasonable, then they can be held to account. If there's a bona fide mistake where you don't see something in the bill, then that speaks to the reasonableness. And if you look at what happened in the Western Cape, for example, the department made a presentation to the committee. The committee looked at the long title of the bill. In fact, in the Western Cape, it was accurate to say that it will affect mostly Khoi and San people because of the policies of influx control, etc., where they shipped African people out of the Western Cape. There was no communal system here. And so that would be true. But if it was in another province and the department made a presentation to say, this is the substance of the bill, they're just there as an actor, helping them as the draft of the bill. And if they make that presentation to the legislature goes with what they say. They look at the long title and say, oh yes, this is true. And they go out and they have public participation and they are wrong. Then this won't fall under the criteria of unreasonable.
Mr. Basson, just finally, I think we should be careful again when we sort of develop a hierarchy of people with LLMs and people who work in factories. I'd like to work from the assumption that if someone puts up their hand to be elected to discharge a constitutional mandate, which is the making of legislation, that it's incumbent upon that person to know what the legislation is about in their engagement with the public. And if they fail in that regard, then it doesn't really matter whether they have an LLM, because they hold public office and they get paid through the public purse. And the consequence of them not discharging their duties can be quite drastic. Yeah.
I take the point.
Mr. Vet.
Mr. Vasan, I just wanted to respond to something you said. It appears that the Western Cape is patting itself on the back that out of all the provinces, it did well. But as far as I understand it, the applicant's papers tell a different story because it is also accused of having given people wrong information, not in describing what the bill actually entailed, but it said the consultation report, that's something else, did not accurately reflect the comments made at the hearing. And people at various places were still given inadequate notices. So it does not appear to me that it conducted itself in an exemplary fashion, as you put it.
Justice Meyer did, in fact, because in terms of the standard operating policy, 7 days was the least that it should have. And in fact, the Western Cape Provincial Parliament explains that we wanted the hearings to the adverts to God sooner. There was a problem because we couldn't get 3 quotes. There's a procedure to follow. Because there wasn't 3 quotes, we had to do a deviation. And in that deviation, there was a slight delay because the advert couldn't be timelessly published. But the shortest period before it was sent out was 7 days. Now, the applicant says 7 days is too little, 30 days is too much. And this is the problem that the legislature has when it looks at the minutiae of if 7 days is too little, 30 is too much. How does the legislature reasonably carry out public participation with always having the fear that it has failed? There's no certainty in what happens. And when we speak to the criteria of minutiae, some of the criticisms are, there was only 1 set of adverts. Why? You sent it to all the media houses. Did you follow up? Why did you not follow up? So they make a signboard, they send it out. Did you ensure that it was sent out? This is not the criteria. When Doctors for Life says you have such a broad discretion, Mautse says that you can creatively use this to reach out to people, and this is what was done. So I think they are correct in patting themselves on the back. They reached out to all the mayors, they reached out to all the municipal managers, to 200 community development workers, in addition to the normal things that happen. Sound bites were made, radio interviews took place. So I think they fulfill at least the criteria of reasonableness. Justice Meyer, I have seen that, and there are some of the criticisms which have been responded to, and they dispense with that. So it has been confirmed that there were translations, and you'll see that in the confirmatory affidavit by the committee secretary. So it's in full compliance with the standard operating procedures. It's in full compliance with, in fact, the policy. The only respect in which the Western Cape didn't comply with even the national policies, that they couldn't translate the bill. And the bill is 96 pages. They're saying they don't have the capacity. And what the speaker says is that even national government says that we don't have the capability to translate every bill into 13 languages. And we're saying that where you have a legislature that's 6 people sitting on a committee, they have limited resources, and reasonableness is the criteria.
I know you've been asked questions from the bench, but you are still left with 1 minute, so you may want to round off.
Mr. Vassen, can I ask you one question?
Yes, Justice Mutale.
Assuming we incline to your view that the Western Cape was perfect and the other provinces were imperfect, what would be the practical effect of that finding? That the entire act has been impugned, so to speak. Can we, or are we in a position to insulate the Western Cape from the other provinces, notwithstanding the fact that this is a national legislation? And if so, how do we do that?
Justice
Or
Mutale.
is it a question of cost only?
No, it's
And
not
what
only a
is it
question
then?
of cost. If the NCOP process has failed, then it's found in failure to comply with Section 72. It's not a specific finding in terms of Section 118 that this provincial legislature also failed in its obligation to facilitate public involvement. And I think that's an important criteria for legislature not to want to fail. It goes to the heart of the legislative system.
Mr. Vassen, may I just ask a question on what has been called standing? I know Doctors for Life discussed this question under the notion of standing, but in having regard to matters such as delay and the extent to which a person sought an opportunity to be heard, might it not be more accurate to say that the court has recognized a discretion whether to entertain a case of this kind? And there are certain factors which it will take into account. Standing more in its proper legal sense appears to me to be black letter law. You either have it or you don't. Whereas the sorts of factors mentioned in Doctor for Life are more policy-based, they involve value judgments, and even on delay it says, save in exceptional circumstances. So are we not ultimately looking at a discretion as to whether to entertain this case given the circumstances? And we might take the factors mentioned in Doctors for Life into account, but we might also take into account the prospects of success, the extent of the alleged failures, and things of that kind.
Justice Rogers, there's Gaba versus Minister for Safety and Security, there's Laupsche versus SARS, which said that where decisions are consistently held without good reason, you don't deviate from them. And this court has consistently held in more than 5 cases the issue of standing and why standing on a procedural matter which doesn't implicate a Bill of Rights combined with delaying non-suits an applicant.
I quickly did the word search on standing outside of Doctors for Life, and I know the delay aspect is mentioned in the later cases you mentioned. I don't see them specifically addressing, as it were, 2 black letter law requirements for standing in these challenges. You must have tried to participate and been denied, and secondly, there must not be a delay. The delay is qualified by save in exceptional circumstances, and I'm not sure that the other cases, apart from Doctors for Life, talk about the extent to which you tried to have an opportunity to be heard.
Doctors for Life does that. Mautse, the Poverty Alleviation Network, and Merifong, they condoned it in those circumstances. But in those cases, what had happened, the circumstances are so distinguished from this. In those cases, the applicants immediately went to the High Court and launched an application. They withdrew those applications to come to this court. In 2 instances, I think they were waiting for the Matatiel judgment.
Yes, but those cases where you were talking about delay.
Yes.
And the very notion that you can condone the traditional approach to delay at common law in discretionary relief, particularly review relief, is an objective question: was the delay unreasonable? And if it is unreasonable, should we overlook it? That's not traditionally regarded as a rule of standing. It's a rule relating to discretionary remedies. And as far as I know, you talk about a consistent following of precedent. But as far as I'm aware, apart from Doctors for Life, the requirement that you should have sought an opportunity and been denied it didn't feature in the later cases, did it?
It did not, but I think the underlying principle is of importance, is that there's a risk that people go back, look at issues of procedure, and then invalidate an appropriation act or any kind of act for that fact. And in a whole different set of circumstances, if you look at the Cagliani case, that involved an extradition matter. And they tried, and in fact, in that matter, the NCOP mandates were deficient. And the court said, no, the delay is too long, you're non-suited.
Yes, but one is not talking about what I previously described as black letter law. One is determining whether it would be just in the circumstances of the case to entertain the challenge. And one can't say this is an absolute imperative or that there's this exact period of delay. There's a value judgment which will take into account all the circumstances as to whether to entertain the challenge.
Then that would need to be distinguished from Cagliani, etc., where it speaks of the very exceptional circumstances. And if you look at the circumstances of this case, what's answered is that there is, for one of the 5 counsel was unavailable for 2 months. This was 16 months after the president had enacted.
I'm not concerned with the application to the facts of this or any other case. I'm just trying to get from you what is the legal approach. And it appears to me there's no absolute time limit, nor is there any absolute requirement of having been denied an opportunity. In fact, in Doctors for Life, the court said, well, Doctors for Life had sought an opportunity and been denied, and secondly, they brought a prompt challenge. And then the court said, well, I think that's what should normally be the case. It wasn't non-suiting a party. It was simply saying, well, this party has done what should ordinarily be done. On another question, can I ask you, accepting for the moment that a challenge of this kind isn't governed by Section 38 because it's not based on an alleged violation of the Bill of Rights, do you say that an organization such as the first or second applicant cannot, I forget, but an organization, or for that matter, the first applicant, Ms. Magali, can there be litigation of this kind in the public interest? And I ask that because I think we must accept that in a country like ours, and particularly in legislation of this kind, one can imagine that there are millions of people who have no prospect of bringing their cases to court, their concerns to court. Do you say that an organization or person may bring a challenge in the public interest? Saying, because if they can, it would imply that even if that person had an opportunity to be heard, they would say, but I know what went wrong with this process, and I know that hundreds and thousands of other people didn't have a chance to be heard. And I'm interested for them as well. So do you accept standing in the public interest in this type of litigation?
Yes, Justice Rogers. But where that standing happens and there's delay, then the restrictive approach should apply. So in our country, yes, that should happen. There should be a broader approach to standing, but where it's combined with delay on a purely procedural matter, then the standing rule in Doctors for Life, in Mautse, etc., should be upheld. I think the combination of the two is the solution, and it's just and equitable under those circumstances.
Mr. Vasan, if I may, you referred to Kaba. Wasn't Kaba on jurisdiction, not on standing?
I didn't hear you, Justice Turan.
You referred to the case of Kaba, if I heard you correctly. No, you didn't.
Oh, yes, I did. Sorry, I did.
Yes, Kapa dealt with jurisdiction, notwithstanding,
Yeah, but then
and that jurisdiction determined from the pleadings.
And Lobsha recently upheld that to say that this court shouldn't deviate from its previous judgments unless there's very, very good reason to do
There's
so.
a difference, the point I'm making is a difference between jurisdiction and standing.
Yes.
And that Kaba is not relevant to this matter in relation to standing. Unless there's a different aspect of Kaba you wish to rely upon.
But what Lobsha did is to incorporate the previous matter in line with consistency and said that, and that's, I think it's a 2019 or 2021 judgment by this court, Lobsha versus SARS.
Yes, and just to follow up on a question from the Deputy Chief Justice about some of the flaws alleged by the applicant in the process conducted in the Western Cape. It says that at the Oudtshoorn hearing, only 10 people, mainly traditional leaders, were allowed to speak, and that other attendees were prevented from speaking. And it's also alleged that at Swellendam, traditional leaders were given advance notice of the hearings, but most of the community members only found out on the day of the hearing. And it's also said that the consultation report didn't accurately reflect attendees' comments that were made by the hearing, as well as the portfolio committee's report also inaccurately reflected that the public supported the bill. These are some of the allegations made by the applicants about the defects in the Western Cape.
That's the National Assembly, not the provincial legislature, Justice Ron.
But it still falls in the Western Cape,
No, it
doesn't
falls, and it's a separate legislature that would fall under Section 59, because Parliament consists of the Assembly and the NCOP, and if the NA process was flawed, then that's a failure in terms of Section 59.
But where we're dealing, as Justice Majik put to you, we're dealing with national legislation.
But it wouldn't fall on the Western Cape Provincial Parliament. Those were members of the Portfolio Committee from the National Assembly. And if you look, Justice Theron, if you look at what Section 42 and 43, so Section 40...
I'm struggling to hear you.
Sorry,
Mr.
Justice
Rossington.
Theron. So if you look at what Section 42(3) of the Constitution says, is that the NCOP represents provinces to ensure provincial interests are taken into account in the national sphere. 43B says in South Africa, the provincial sphere of government is vested in the provincial legislatures as set out in Section 104. So they have these distinct roles. The National Assembly is elected to represent the people. The NCOP takes provincial issues at the national level. And what the provincial parliament does is they bring these provincial issues in the province to national level. So when the NA conducts its public participation, it's very different to the provincial parliament in that respect.
Thank you.
Deputy Chief Justice, if there are no questions, those are my submissions.
Thank you very much, Mr. President.
Thank you, Deputy Chief Justice Moya and the Court at Large. The 12th respondent submission is the following. It is submitted that the applicant's invocation of the exclusive jurisdiction of this court in terms of Section 167(4)(e) of the Constitution is ill-founded. The crux of the relief sought by the applicants as contained in the notice of motion in the substantial part of their submission in the founding papers is that the Traditional and Quayside Leadership Act be declared unconstitutional and invalid. This is evident in the applicant's founding affidavit, which is, in the main, concerned with the alleged shortcomings of the provisions of the Article A Act, rather than the alleged failure of Parliament and the provincial legislatures to comply with the constitutional obligation to engage the public. Contrary to the applicant's first prayer in the notice of motion, the department submits this application is not in the essence about the alleged failure of Parliament and the provincial legislatures to comply with the constitutional obligation of ensuring that reasonable public engagement is embarked upon prior to the enactment of the Article A. This application is about invalidating the TKLA through direct access to this court without having to make a proper case of direct access to the on the papers required in law. The real ground upon which the applicants seek an order of invalidating against the TKLA is that the provisions of the Act are unconstitutional. The applicants are quite simply not satisfied with the provisions of TKLA and admit as much in their founding papers. This admission supports the inference that the approach of seeking a declarator on the grounds that the Parliament failed to fulfill the constitutional obligation to engage the public is but one strategy that they are pursuing in the broader scheme aimed at invalidating the TKLA. If one is to refer, if I had to refer this honorable court to page 50 of the paginated papers at paragraph 110, it is very clear that one of the attacks against the TKLA is unconstitutionality, and it relates to the substantive part thereof. According to the applicants, the TKLA undermines the deep roots of democracy, accountability of customary law. It risks turning traditional leaders into an accountable and undemocratic sphere of government. The other attack is the issue of the Bantustans. It is very clear that there is a message which has been conveyed to the public that this particular act promotes the Bantustans. It is no wonder that the court is full of people with shirts mentioning the Bantustans. That is not the case about the TKLA. And we will show that the TKLA promotes democracy and promotes the women's rights. The department disagrees that the matter falls within the ambit of section 167 for E and submits that the application, in fact, indirectly seeks to challenge the constitutionality of the provisions of the TKLA. It is evident from the applicant's voluminous application that it was challenged. What is challenged is the TKLA itself. The paper contained an in-depth analysis of the various clauses in the TKLA and the extent to which these sections of the TKLA are allegedly inconsistent with the Constitution and therefore invalid. In the case of Gaba versus the Minister of Safety and Security, on approach to challenge claims on this court's exclusive jurisdiction are instructive. The court stated, while the pleading, including in motion proceedings, not only the formal terminology of the notice of motion, but also the contents of the supporting affidavit must be interpreted to establish what the legal basis of the applicant's claim is. It is not for this court to say that the facts asserted by the applicant would also sustain another claim, cognizable in another court. If, however, the pleadings properly interpreted establish that the applicant is asserting a claim under the LRA, one that is to be determined by the Labour Court, the High Court would lack jurisdiction. It is our submission that at the heart of the argument is the essence of the TKLA. We further submit that the TKLA is not open to the applicants, particularly at this stage, to try to expand the scope of the TKLA. Further, the TKLA does not have the duty to address several multiple defects that may or may not be existing in legal framework regarding customary law and land rights. The TKLA does not regulate land rights at all and cannot prejudice, and there can never be any prejudice created by the TKLA on communities in this regard. Significantly, the TKLA in its procedures of recognition speaks of areas of jurisdiction, not boundaries of Bantustans borders. In fact, there is no such words in the entire TKLA. The requirement for jurisdiction in itself does not offend the Constitution, customary law, common law, or the principle of justice. Further, the TKLA makes it more it is denied that the TLA makes it more difficult for a small community to leave a large community. The TKA, in particular, ensures the inclusion of communities in their own affairs and the protection, notwithstanding the provisions of any other law. In other words, these requirements are saying that no matter what any other legislation says, including the Interim Protection of Land Affairs, Land Rights Act, these partnerships, there are partnerships in terms of Section 24, must be to the beneficial of the community, must be in agreement and in consultation with the community. Section 24, therefore, of the TLA does not exclude the application of other laws, but it merely requires of partnerships and agreements entered into in terms of other laws to comply with the provisions of Section 24. It is submitted that even if the best laws can be broken in this country, it is for this reason the 12th respondent understands the applicant's frustration triggered by previous traditional leadership issues. Be as it may, even the best law, if not implemented correctly, can be taken advantage of by criminals. Even the best constitution in this country, in the world, can fail if we fail to implement correctly, will automatically lead to disaster. However, that is not necessarily an indictment on the constitution itself. The department understands that there are reasons historically for the applicant's apprehensive views. However, there is no factual reasons indicating the TLA does not pass constitutional muster. The TLA goes a long way to address several shortcomings of the TLGFA, the Framework Act, complained of by the applicants to protect the interests of the public. For example, the Department of Home Affairs is working in partnership with traditional leaders, requiring traditional leaders to collect information about the deaths of their subjects, and bring such information to the department's attention, which will do the registration. The Department of Home Affairs is a national department, but the traditional leadership exercise the role at the local level. The traditional leaders who are assigned the role of are performing this role at their local communities only. Another example relates to the COVID-19 pandemic. Now a partnership with the Department of Agriculture, Rural Development, and Land Reform, and with the support of the Solidarity Fund, the institutions of traditional leadership assisted in the distribution of food vouchers using their networks of traditional councils to make sure that many rural communities could be reached. The partnerships with traditional institutions may not always arise or be necessary. However, when those circumstances arise, the TLA is able to regulate those partnerships and so provides safeguards for the community's interest far better than any legislation before it. The partnerships could be argued aid in the functional democracy. In closure, methodology.
And the 10 minutes, that protected zone has just slipped through your fingers, Mr.
In closing,
Mr. Mashawa, before you close, do I understand your argument correctly that it's about the merits of the TKLA and the upshot of which is that it's a good legislation? Do I understand you correctly?
it's so, Your Lordship. Justice Matlanga.
Does that assist us in what the debate is about? Because the debate is about whether there was public participation. It may well be very good legislation from where you are standing and from where your client is standing. That may well be so, but is that not besides the point? If the point is, was there public participation? Because other people may disagree with you about whether it's good legislation or not.
So.
But even assuming that you are correct, that it's very, very good legislation. Point is, the applicants are saying no public participation or meaningful participation, or what what the relevant respondents did with regard to public participation was unreasonable. That's the point of it, good or bad. Your argument would not be addressing the real issue.
Indeed, we are saying, Justice Madlanga, if we were to accept that reading the papers of the applicants, the application is not only procedural but also relates to substantive part of it, that does not fall within the ambit.
Yes, you do. At the beginning of your argument, you do make that point. It's almost in passing, and then what you zoom in on for the better part of the, in fact, 99% of your argument is about how good this piece of legislation is. Does that assist us in the debate that we are about?
Justice Madlanga, our argument or our submission is that this particular application, upon proper looking at the pleadings of the application itself, is a substantive application or attack on Article A. And if the court is to agree with that particular argument or submission, then it does not give the applicants direct access to the Constitutional Court. They should, or they ought to have, then go through the normal route of going to the High Court, Justice Malanga. That is the essence of.
That's not the only, but even assuming that when we sit down and look at the matter after argument, we feel that you are quite correct with regard to, must we look at whether it's good legislation or not, and we agree with you that no, we don't get there. What remains? Is that not an exclusive jurisdiction matter?
Justice Malanga,
Outside of your 99% argument, what remains? The 1% does it not fall under exclusive jurisdiction?
Justice Malanga, hence you are saying, if the essence or the substance of the application is not necessarily against the public participation, but the essence is about the substance of the act itself, then it does not fall within the ambit of Section 167(4)(e) of the Constitution, which gives them right then to apply directly to the Constitutional Court.
So we must forget the argument that Mr. Badlander presented for quite a long time about public participation. Because of the submissions you have just made, we must forget all of the argument that Mr. Badlander presented around public participation.
No, Justice
And
Malanga.
on which Ms. Adhikari then gave examples of why the applicants say there was no meaningful public participation, or that the relevant functionaries acted unreasonably. So we must forget all of that
No, Justice
and
Malanga.
just focus on this 99% that you choose to argue on.
No, Justice Malanga, we are not saying the court should ignore the procedural part. We're saying, in terms of the case which I've just mentioned, Justice Malanga, the Gaba versus the minister, we look at the pleadings of this case. And our submission as a department is that the substance of the application is about the substance of the Article A. It's about the substance. It's not about the procedure, but it's about the substance. That is why it talks about the unconstitutionality of some of the sections. That there is no, it entrenches Bantustans. That is in relation to the substance of Article A. Hence, we're saying it's not about procedure, but it's about substance. And it does not then, as a result of that, fall within the ambit of Section 167(4)(e).
One last question. So I was saying it is 100% about that and nothing more? 100% about that?
No, Justice Malanga, I'm not saying it's 100% about that, Justice Malanga.
So what is outside of that, does it not fall under our exclusive jurisdiction? Once you accept there's something outside of what you are arguing, that which is outside, does it not fall under our exclusive jurisdiction?
Our submission, if one is to look at the case of the Gaba versus the minister, looking at the pleadings itself of these particular papers, the attack is on the Article A. That is our submission. And if that is the case, then it relates to substantive part of it.
I'm sorry to interrupt, my brother, But Kawa concerned whether or not the High Court versus the Labour Court had exclusive jurisdiction, which is very different from what we're dealing with here, Mr. Michelle.
Indeed.
I'm not sure, and I said this earlier, if Kawa is relevant in this matter.
Indeed. Indeed. The point the 12 respondent is making, Justice Theron, is that if one looks at the pleadings of this particular case, the applicant's application in the pleadings, it is a substantive attack on Article A.
Let's assume it's both a substantive and procedural attack. If they're wrong in respect of the substantive attack, on the procedural act, would this court have exclusive jurisdiction?
If the court is to find that indeed the application is about the procedural also, hence we're saying the actual intention of the applicants is to get direct access, but the main point is to attack the Article A. That is our point.
Yes, thank you, Mr. Michelle.
Thank you.
Sorry, Mr. Mashaba, I confess I don't understand this argument. As I read the founding papers, it's 100% about process. I presume you would accept that a person can have a legitimate complaint. So it's not either or. There can be genuine complaints by a person on both. Now, you took us to paragraph 110 of the founding affidavit, which is at volume 1, page 50. The applicants have been advised that parts of the act are substantively unconstitutional. A couple of sentences in which that is elaborated. But you didn't read paragraph 111, which says, I do not intend to set out fully these challenges. The applicants will do so in the High Court if this challenge fails. I merely summarize them because they clarify what would constitute reasonable public participation. The applicant, every meeting, at every stage along the process, if what they really were asking this court to do was to decide a substantive challenge. And I'm sure Mr. Budland will tell us in reply that if we think this application is about a substantive challenge to the constitutionality of provisions of the Act, or about the constitutionality of its substantive provisions, he has made it clear, and I think the applicants made it clear in their papers, that this is mentioned only, first of all, to foreshadow that there might be such a challenge in the High Court if the procedural challenge fails. And secondly, to highlight the controversial nature of the bill as a factor relevant to assessing what constitutes reasonable public participation. So are you asking us to somehow go behind what the affidavit and notice of motion says to inquire into some secret motive of the applicants? Or do you accept that the case they are actually trying to make out in the founding affidavit is one of inadequate process?
Just I'll submit that upon interpretation of the papers themselves, the biggest chunk on the attack of the substance of the Article A. And if one then is to take cognizance of the case,
Sorry, just a moment, Kate. The controversial nature of the bill as a factor relevant to what is public participation, then Kagaba is irrelevant.
If the court concludes, my apology to interject.
Because the substantive nature of how you go about facilitating public participation. And if the questions of substance are mentioned for that purpose, then they align 100% with a process challenge. I don't read anywhere here, nor one word in the applicant's written submissions in which they are seeking to argue that any provisions of this act violate any provisions of the Bill of Rights? Not one. Can it any substantive provision?
Justice Thorough, if I may refer to the court, the attacks I will submit, they're not referring to the Bill of Rights, but attacking the substance of the act itself. Justice, but not to the Bill of Rights, of course. That I will concede.
Yes, so clearly they are unhappy with the substance, and they've said they're going to bring a challenge in the High Court if this one fails. It doesn't mean that this challenge is the substance challenge. They've expressly said they are to suggest that because they have those substantive concerns, we must read this application as being the substantive case. Do you accept that they have legitimate, that they have genuine process concerns?
May I follow that up, please? Because I expressed when Mr. Butler, the department stands in this case, it was almost in this manner, where the fight really is about process. This is the fight of the speaker and the applicants, or the speakers and the applicant. It wasn't really the minister's fight. Now the minister comes in sideways and says, well, you know, this is actually a ruse. And I wouldn't put it as high as Mr. Butler, but I found it quite disappointing, to put it mildly, that the minister would come and say, all these people, the efforts that they've made, is really a ruse because they're taking a sideline, they're circumventing the direct access provisions of the Constitution to come to this court directly. Now, with that introduction, let me take you to your heads of argument. Have you got your written submissions there?
Yes, sir. I do.
Page 15. You make this point, and I'm not going to read it to save time. Page 15, paragraph 18 at the top. Constitutional challenge. It's got nothing to do with procedural complaints. And then, quite interestingly, footnote 11. You see it?
Yes,
You cite founding affidavit, paragraph 71 to 141. Now, what Alice says at the beginning, this is who I am, these are the other applicants are. I'm going to set out in part 1 the following. And she says in part 4, I'm going to talk about the significant impact of the TKLA. Now, that's paragraph 71 to 141. And what does she say in 71? I must read it in full because it illustrates the point that I'm making, and that my brother Rogers has made just before me. What constitutes reasonable public participation depends in part on the nature of the legislation. Laws require less public participation, or they may require consultation primarily with a particular group, and then 72 laws that make major changes affecting all or most of the partial law. That's her introduction. So this has got nothing to do about substantive challenge. She sets the background. And we know public is the same thing. So this is a constitution.
Hence, Justice Majid, if one takes a look at the papers of the applicants, they say in Washington terms, the constitutionality of the TKLA. In page.
Too short, but do you see understanding? And then they do it. They say we are explaining to you the significant impact of the TKLA to illustrate to you why there was widespread
Justice Majid, if one looks at page 50 from paragraph 110, it says the decree is unconstitutional. So automatically it deals with the constitutionality of. But if the arguments that is my submission.
I don't think I'm going to spend much more time on this. Thank you.
I'm not sure if it's beneficial to prolong this indefinitely. But it seems that you take the view that the attack is a constitutional, a guise for disguising a constitutional attack. You've elected to advance arguments purely on the basis of the constitutional attacks, any arguments on the procedural challenge that was really the subject of most of today's hearings. And if that's your election, then I suppose we must accept that. Is that the correct understanding of
Indeed.
what you're saying?
Indeed. As far as
We must accept it with the consequences.
Shaba, do you still persist with the argument that you raised in your papers about the dispute of fact in the light of what my brother Kolapen has put to you about not proceeding on the procedural aspect, but the constitutionality of the act?
I'll leave that point. No. Thank you.
Thank you, Deputy Chief Justice. It's been a long day. I'll try not to make it very much longer. The matters which I wish to address are of what in particular in relation to what happened in the consultation processes in the provinces. And this is explained by, was explained by this court in the Lamosa case at paragraph 71, where Justice Madlanga, speaking for the court, said the negotiating and final mandates of provincial legislatures. I will not burden the judgment by repeating them. Suffice it to say that the views and opinions expressed by the public at the provincial hearings did not filter through for proper consideration when the mandates were being decided upon. This deprived the process of the court explained that either the hearings which are held around the province, or they must get reports from those meetings, and they must bring those reports to the select committee. So they are intended to filter back because there's to be a process of debate and voting ultimately. Not voting, but debate and mandates, and then voting.
Sorry, Mr. Badbert, cannot. What that is talking about is as between the public hearings by a particular legislature and the views of its select committee up to its legislature. It's not concerned with having resolved their individual mandate, what gets conveyed to the NCOP select committee.
Yes, I understand the point, which is contemplated, is that all of the comments will be filtered back to the NCOP select committee, because someone from Gauteng must say, oh, I see, that's what they're saying in Mpumalanga. We hadn't thought of that. That's an important question. How can you make this argument when you have regard to what the public comments were? And the KwaZulu-Natal people may say, oh, yeah, that's a good point. Hadn't thought of that. And so what it contemplates is that there's a process of exchange of information
of what happened at the different provincial public consultations, and that exchange is to take place at NCRP Select Committee. That we submit, that's what the contemplated process is. Then if I can then move on from there to the second question I wanted to address. I won't, in the interests of not being rude, I'll say nothing about that. Then the question of standing and merits. As I understand the law, questions of standing are determined on the assumption that the claim may have merit. Does this person have right to raise the question? That's what standing is about. Standing is not about merits. And the giant concerts judgment makes that very clear. So they are distinct to standing, any more than we can smuggle standing into merits. Fully appreciate the analysis of Justice Rogers as to how these things all come into the pot when you're exercising a judgment about what is just and whether it's non-suited on the grounds of the delay. But those are not standing issues. Those are issues of reasonableness of the challenge, of reasonableness of the public participation process, of whether the challenge is good, and if the challenge is good, what the remedy should be. And we insist that two standing and remedy need to be, I beg your pardon, standing has to be considered quite separately from merits, or for that matter, delay. Then our learned friend, Mr. Kasim, made a number of references to the resuscitation of apartheid laws. And I have to say, I didn't understand that at all, with due respect to him. Perhaps I wasn't listening carefully enough. But just to be clear, they're appealed by the TKLA. They are listed in Schedule 4 to the TKLA. They are what we call the TLGFA of 2002. There's the 2009 Amendment Act to the TLGFA, and there's the National House of Traditional Leaders Act, which I think is 2003, I'm not sure of the year. Those are the laws which are repealed by the TKLA, and those are the laws which will, if the TKLA finally falls, will come back into operation. But there's no resuscitation of apartheid legislation. The Group Areas Act is not an issue in this case. So with respect, I advanced, but if I understood the submission correctly, that one of the reasons the applicants should not be allowed to litigate in the public interest is that it's not in the public interest that this old legislation be resuscitated. It's only the post-2003, roughly 2003 legislation which will be resuscitated. That brings me then to the question, the public interest brings me to the question of who the applicants are and what their standing is. And I have to say it is offensive, and I'm sorry to use that sort of language, to hear Parliament, through its council, saying this is just four stray individuals who speak for nobody else. Those are not the facts in this case. The facts in this case are quite different, and they're not disputed. This is what, from page 18 of the papers, the applicants say who they are. Ms. Mokhale says, I'm the national coordinator of the Alliance for Rural Democracy. The ARD is a grouping of civil society organizations and individual activists that have joined together to contest policy and legislation that undermines the rights of rural citizens living in the former Bantustans and that threatens to dispossess them of rights in land. She says, I bring this application on my own behalf, as Ms. Mokhale, on behalf of the ARD, which we know in turn represents civil society organizations and individual activists, and in the public interest. I'll come back to the public interest in a moment. The second applicant, the Land Access Movement of South Africa, LAMOSA, is an independent federation of community-based organizations advocating for land and agrarian rights and substantive democracy through facilitating sustainable development. LAMOSA works in 4 provinces, Limpopo, Mpumalanga, Northwest, and Gauteng. Its constitution caters for community membership and individual membership. And the second applicant says, and LAMOSA brings this application, it says, on its own behalf as an organization, on behalf of its member organizations, that is the civil society organizations, or rather community organizations, and in the public interest. The third applicant is Mr. Dlamini. He is an elder of the Mgungu Ndlovu community. He's an induna of the Nkosazana's council. He says he brings this application on his own behalf and on behalf of the Mgungu Ndlovu community. So let it be not said there's no community here, and in the public interest. And the fourth applicant is Mr. Modi Makwane, who's a member of the Bakhatla Bakhafela. He brings this application in his personal capacity and in his personal interest. For Parliament to say these are 4 stray random applicants who speak for nobody else, and therefore, for reasons which in any event are not clear, the application has no merit, I submit is entirely without foundation. That brings me to the question of public interest, whether non-Bill of Rights challenges can be brought in the public interest. And a learned friend of the Western Cape fairly accepted that they can be. That's happened before in this court. It happened in the Albert case. The Albert case was a rule of law challenge. It was a rule of law challenge to the dispensation for pardons for political offenders. And it succeeded as a rule of law challenge on the ground that the procedure which was followed was irrational. So it wasn't a Bill of Rights decision. It was on the basis that the procedure which the president followed, not consulting the people affected, was irrational. And the respondent in this court, the applicant in the original case in the High Court, the Center for the Study of Violence and Reconciliation, was allowed public interest standing in terms of Section 38D, because the court accepted that those, and it goes back a long way to the earliest days of this court. The court, I think in Ferreira Levine was the first time the court said, the Constitution creates a broader notion of standing than existed in the common law. And it didn't limit that just to Bill of Rights challenges. This new Constitution and the new approach to access to justice and the new approach to the rule of law meant that standing has been expanded. We no longer go back to the old standing cases and say, oh, well, those are the only people who got standing. You've got to look at what Section 38 says, and you've got to look at what I think Justice Sachs would call its irradiating influence. It permeates the other parts of our law. And so public interest standing is permissible whether or not there is a Bill of Rights challenge. Then I'd like to address a question raised by Justice Turon, which was about the question of preparatory meetings in KwaZulu-Natal, about which our learned colleague made some rather, with respect, over-enthusiastic statements. The facts are the following. The facts are that Mr. Duda of LARC says, if I just give the court the reference, at page 1114, paragraph 18 of his affidavit, he says, the coordinator of the legislative process in KZN informed LARC that no preparatory workshops would be held in KwaZulu-Natal because of the cost involved. The deponent on behalf of the KwaZulu-Natal legislature admits that statement by Mr. Duda. He says that's correct. The admission is at page 2164, paragraph 84. So it's common cause that when LARC said, are you having preparatory meetings? The province said, no, we are not having preparatory meetings. And to put the matter beyond any doubt, if one goes then to page 2157, which is the answering from the answering affidavit for KwaZulu-Natal, at page 2157, paragraph 59. This is what the deponent on behalf of the Speaker of KwaZulu-Natal says. The deponent says, I admit that there were no pre-hearing workshops held to explain the TKLB due to time constraints. I concede that such workshops would have assisted people in understanding the intention and content of the bill and in making their input. So it's not so that there were all these preparatory meetings held all over the province. If they managed to pull one off in one of the towns, I can't remember which it was, well, that's very nice, but it doesn't answer the point. Then our learned friend for the Western Cape, oh, let me take a step back. So the next question then is the argument about non-suiting as a result, a procedural challenger as a result of delay. And of course, we can all find our favorite passages and our favorite sentences, our favorite judgments, and the sentence which we most favor in our favorite judgments. In the end, we submit that what the court will do is look at what the court has been undertaking in this exercise, and in particular, the court's concern to avoid encouraging or facilitating belated opportunistic challenges when somebody suddenly sees the sharp end pointing towards him or her. And so that's what the rule which the court developed is about. And if one looks at what has happened in the cases, there are two cases, and I admit to cherry picking, because everybody's engaging in cherry picking here. There is no solid black line which starts here and ends there, and everybody on that side of the line is out, and everybody on that side of the line is in. Life is more complicated than that. If that was how the law worked, this court would have much less difficulty with its business. The fact is that the line is seldom straight, and you can seldom find a line at all, and if you find a line, it's blurred, and because you have to look at the facts and the circumstances of each case. And so having uttered that caveat, admitted that caveat, let me just refer to two cases which underline the point which we seek to make. And they are referred to in our heads of argument of the first and second applicants, at paragraphs 35.1 and 35.2. In 35.1, we point out that in the Merafong case, the applicants challenged a constitutional amendment that had been signed and brought into force more than a year later. And Justice van der Westhuizen held that though regrettable, the delay should not prevent the matter from being considered by this court. He recognized that considerable time had elapsed, and the issue called for a speedy determination. But this court ultimately determined the merits, went on to the merits, said notwithstanding the delay, we go on to the merits because the applicants did not only, quote, represent individual interests or the interests of the organizations only, but views widely held in the community of Merafong. Though we say that is exactly what the position is in this case. Then in the Mutse case, the delay was even longer. But let me interrupt myself. So the court admitted the application. It said, notwithstanding the delay, we allow the application will be heard and dealt with on its merits because of the nature of the challenge and its impact on the people concerned. The court considered the merits and found that the challenge didn't have merits, failed on the merits, not on standing, not on standing, I'm getting confused now, not on delay, but on merits. In Mutse Demarcation Forum, the delay was even longer. More than 2 years had elapsed from the time the challenged law was enacted. One of the Justice Jafta held that while delay was, quote, undesirable, close quote, quote, it would, quote, not be in the interests of justice to non-suit the applicants on this ground, close quote. And he gave 4 reasons. He said, firstly, the respondents were alerted quite early to the fact that the applicants were challenging the constitutional validity of the statute. Well, in this case, letters were sent to the president complaining inter alia about the procedure If I can just give the court the references. It's founding affidavit CM67 at page 604, sent on the 4th of September 2019. And again, CM68 at page 616 of the founding affidavit, sent on the 10th of April 2020. So there was some notice given at an early stage that this is no good and we're going to challenge it. Then he said the second reason he gave for allowing the challenge to be brought in the interest of justice was he said the respondents were able to put up evidence on what occurred during the consultation process. Well, that is what happened here. Western Cape put up a lot. The Parliament put up less, and the others all chose not to come and tell the court anything at all. So it can't be said that the respondents were prevented from putting up evidence on what had occurred. Then the third reason he gave was that the blame for the delay can be attributed to the applicant's lawyers only. That's also the situation here. And the fourth reason he gave was that it would be practically possible to reverse the effect of the challenged law. And that is also the case here because there's been such limited implementation of the TKLA. It hasn't even got to crawling stage, let alone beyond crawling stage.
Mr. Butlander, sorry, have you given some thought to the question I asked you? Because the submission from the Western Cape is that these cases are distinguishable, Mutse and Merifong demarcation, and they also submit that there's not a single precedent where legislation has been invalidated simply on the basis of procedural challenges where there's been this kind of delay.
Justice Majid, there are cases, and I always remember them, and my learned juniors will remind me, there's Doctors for Life, there is Matatiele, and there is Lamosa. So those are three procedural challenges which succeeded to legislation. I think, Justice Majid, you may have misunderstood what I think our learned friend for the Western Cape was saying. I think what he was saying is there is no case in which delay was raised and nevertheless a procedural challenge was
That's
allowed.
exactly what I asked. That's what he says. He says, after such a significant delay, there's never been a case like that.
No, well, that is so. That is so.
In all fairness, I suppose the short answer is there's always a first time, especially in an apex court.
That's right. I was once a member of an organization. I was a young member, and the older people were very opposed to the Young Turks. And they said, you must never do anything for the first time. Whenever we proposed anything, they said, oh, but you can't do this. We've never done it before. And of course, that leads to an inevitable shifting or shrinking of what you can do. Yes, there's always a first time. The fact that in some cases, the merits, the challenge is not allowed, doesn't tell you whether the merits should be upheld in this case. You've got to look at each case on its own merits. And we're not suggesting that Merifong was wrongly decided or that Mutse was wrongly decided. It was correctly decided. The court correctly decided to hear the challenge, notwithstanding the delay. And the court then said on the merits, this is not a good challenge. And we asked this court to do the same. We asked the court to exactly the same as what was done in that case, those cases. We asked the court to allow the challenge, notwithstanding the delay, and then decide the merits. That's all we're asking for.
Can I ask you something on remedy, lastly, from my side? I'm looking at your notice of motion.
Yes.
Given what the Western Cape's position is, you still ask for an order against Parliament and all provincial legislatures, including the Western Cape.
Yes, we do, Justice Majid.
And then lastly, you remember we spoke about what the order was in Doctors for Life, and you thought that you should insert the words in paragraph 3 of your notice of motion order for Parliament, to enable Parliament, that's the invalidity suspension, for Parliament to decide whether to reenact the statute. In the light of the fact that Doctors for Life didn't insert those words, simply says for Parliament to reenact the statute, what is the position now?
We submit that it would be more appropriate to allow, to say that the order is suspended for 18 or perhaps 24 months to enable Parliament to decide whether to reenact the legislation or to enact other legislation dealing with this, and that the suspension will come to an end either when the 24 months or 18 months has passed, or when the substitute legislation, if any, has been enacted. And it just freezes the situation for 24 months. I'm grateful to Justice Majid for raising the notice of motion, because there's one other matter I need to draw to the court's attention in the notice of motion. There's a patent gap in the notice of motion in paragraph 2 of the notice of motion. Paragraph 2 I beg your pardon, paragraph 1. It's declared that Parliament and the provincial legislatures have failed to comply with their constitutional obligation to facilitate public involvement, as required by section 72(1)(a) and 118(1)(a). It should read by sections 59(1)(a) and section 72(1)(a) and 118(1)(a). 59(1)(a) is the obligation of Parliament, and that's been pleaded. That's what the case has been about. That's what we argued about all day. But there's an error which, with respect, should be corrected. Then, almost finally, pre-finally, a learned friend for the Western Cape legislature laid a great deal of emphasis on the Quagliani case. And the Quagliani case is actually very helpful because it illustrates what the delay rule is about. Quagliani was about a man who was about to be extradited for an offense he'd committed. And he, 8 years after the extradition agreement had been challenged, I beg your pardon, 8 years after the extradition agreement had been signed, he challenged its validity on the grounds that the correct procedure was not followed in signing it. And the court said that is an opportunistic challenge. He never had any interest in it at the time that it was done. He didn't come along and say anything. He's just latched onto this as an opportunistic stratagem to try to avoid being extradited. And that is a classic case where the delay rule is applied, and it illustrates with respect why this court was correct in adopting the delay rule, because otherwise you can get people scratching back into the archives for years and years and years to find procedural defects which they'd never had any interest in, and saying, aha, you can't do this now because something went wrong in 1943, or in 1973, or in 1993, or in whatever. That's not this case. This case is about people who actively participated in the process, who complained about the process, who monitored the process, who produced reports, who wrote to the president, and when it all came out in the wash and when the act was passed, the time came to stand back and say, well, now let's see, what was this really like? Stood back, looked at it, took it in the broad conspectus on the basis of all the reports they received from all of the 9 provinces and said this process was not reasonable. That could hardly be more different from Quagliani. Then, as to our learned friend from the 12th respondent, I take up the invitation from Justice Rogers to say, we do not say that we have made a case that the TKLA is inconsistent with the Constitution. We do not seek an order that the TKLA is inconsistent with the Constitution. We have made no submissions on that question, and that is a question which may or may not one day come before another court. But we've never made that case. We've never sought to make it, and the the procedural challenge stands on its own merits. It's certainly not a ruse. All the effort that went in and all the pain and suffering that went in were because people affected were genuinely concerned that they weren't being heard. And that's the complaint they raise. And then finally on that question, our learned friend says that I don't know what percent it is at the moment, pages of the founding affidavit deal with the merits of the Act. We've checked that. The founding affidavit is 189 pages long. 26 of them deal with the merits of the Act. It's about 13%. It's the same, 13.7, the same percent as the Bantustans. And the rest of it deals with the the procedure, and the founding affidavit makes it very clear that the merits of the legislation or its controversial nature are addressed to demonstrate what sort of consultation process would be reasonable and why there is a heightened need for a very careful and thorough consultation process on this bill. Not consultation process, public participation process, which is much stronger. And so we submit, those are the only matters which I have arising in reply, unless there are matters which members of the court wish to raise with me.
Mr. Budlinder, what do you say about costs?
We asked for costs. We had a debate walking up the steps here as to how many costs, or how many council we should ask for. The matter is quite complicated, actually. There have been 5 council involved. There are 5 council here today. This is the first time that all 5 of us have been in the same room, because the case has been split up and different people have done different parts of the work. So there hasn't been.
I don't know if the number of council makes for complexity of a matter, Mr. President.
It has to do with the complexity. It's a way of addressing the complexity of the matter that you see, Justice. We say two council are not enough. We say it should be 3 council. In fact, in the I think it was in the Lamosa case, or in the in Tongwane, same situation arose, a very big case, multiple things, multiple council, 5 council. This court ordered the cost of 5 council. On the basis, 5 council were so employed on the basis that there was an assurance given by Mr. Trengo, leading for the applicants, that there had been no duplication, and so one could safely say all 5 council where they were employed. That is actually the case here, but we'll settle for 3.
3 is the request in the notice of motion. Mr. Budlinder.
I can't remember what it says.
Page 3, volume 1.
I hope we asked for 10. Three. That was a good guess that I made. That's what we asked for. That's what we asked for, Justice Strong.
Thank you very much,
Deputy
Mr. Budlinder.
Judge. Thank you.
Judgment is reserved. Court adjourns.